Welcome back. This is entity formation. Entity formation. So, let's talk about entity formation. What is it about entity formation? First, what is an entity? Without going into too much words, an entity is a person. An entity is a person. So when we say a corporate entity, we mean a corporate person. That goes without saying. But what does it mean to be a corporate person, a corporate entity? We have to bear in mind first that there are two types of persons. We have an artificial person and we have a natural person. Natural persons include yourself and myself, whereas artificial persons are the businesses, organizations that we set up. The law sees them as persons, though they are artificial persons. So we'll be looking at how do we set up these artificial persons for the sake of running a business. Why would people not do businesses as themselves, not natural persons, and decide to set up an artificial persons to do business? These are the things we'll be looking at. But I can give you a tip ahead of time that one of the reasons is that because they want to limit their liability. Due to the fact that these artificial persons are seen by law as persons, so they have their rights, they have their obligations, they have their liability. And when they breach the law, their liability is on them. Most times, not necessarily on the people running them. But let's get back to how to first form an entity. Forming a business entity is an important way to protect oneself from liability, and another way to maximize your profits and attract a caliber of clients and investors that ordinarily you wouldn't have if you are going by your natural self. You see, a business entity such as a corporation or limited liability company is legally a separate person from its owners. As an artificial person, it also has rights and obligations conferred on it by various legislative enactments. There are some key things to keep in mind when you go about forming or setting up a business. So let's look at the paperwork. To form or set up most business entities, you must file a form with the state agency that handles that business filings. This process varies depending on the country you are in, along with a filing fee and other supporting documents. After the state receives successfully processes your formation paperwork, you may receive a certificate confirming that your new company officially exists. In North America, for instance, one of the major supporting documents used is a corporate charter, which is the equivalent of memorandum articles of association used in some parts of Africa. A corporate charter, also known as a charter or articles of incorporation, is a written document filed with the Secretary of State or Registrar in Canada by the founders of a corporation. It details the major components of the company, such as its objectives, the structure, and planned operation. That's like it emphasizes on the object of the business, the reason why this business is set up. If approved by the state, the company becomes a legal corporation, that's a legal entity, corporate entity. And let's proceed now to examine the steps in forming this legal entity using Nigeria as a case study. In Nigeria, for instance, a company can either be a private or public company, which is further subdivided depending on the liability of its members as regards its shares. A company can be limited by shares or limited by guarantee or unlimited, or it can exist in some other forms, and there is no end to other kind of forms that the law may decide to create from time to time. But to concretize a business idea into a company in Nigeria, you can choose from among the following legal entity types. So we have the sole traders, proprietor or sole proprietor. We have the private limited liability company. We have the public limited liability company. We have the company limited by guarantee, also known as the LTGE. We also have the unlimited liability company, and we have the incorporated trustees. So let's take them one after the other. For the sole trader, who is also known as the sole proprietor, is a business enterprise run by a single person. This is where most entrepreneurs fall in. It is the simplest form of business entity, not mandatorily requiring a company registration. In such an institution or a company, a sole trader is personally responsible for all aspects of the business and has unlimited liability to all debts and obligations. You see, there is no difference between the owner and the trade, as the law sees them as one. So this person is doing his business as a natural person under his style. In other words, in official documents, it's usually captured as the owner. Example, John Boski, trading under the name and style of his business. Example, John Boski Enterprises. So it could go something like this: John Boski trading under the name and style of John Boski Enterprises. When it is more than one proprietor running this kind of venture, it becomes a partnership. So you can have something like John Boski and Sons. Both sole proprietorship and partnership are registered as business names under Part B of Company and Allied Matters Act, Section 588, subsection 1. This registration is typically done in the Corporate Affairs Commission. The next one is the Private Limited Liability Company. The Private Limited Liability Company, often designated as LTD, Private Liability Company is an entity separate from its shareholders who enjoy limited liability. This means that their personnel using their personal, which properties and items, possessions, remain separate, and their risk is reduced to only the money they have invested in the company in form of shares. The major requirements for incorporating a private limited company in Nigeria include, but not limited to: 1. The total number of members usually doesn't exceed 50. Members here typically refer to shareholders, and these exclude the employees of the company. The company must have a registered office in Nigeria. A minimum of 2 people above 18 years of age must subscribe to the Memorandum and Articles of Association. The name of the company must not be misleading. It must not be prohibited, like it shouldn't be a prohibited name or restricted under the CAMA. By CAMA, I mean Company and Allied Matters Act. And it should be as consistent with what the CAMA regulates. Now we have the Public Limited Liability Company, often designated as the PLC. A public limited liability company, unlike a private limited liability one, is allowed to be publicly listed and sell its shares to the public. This is often done under the platform of the Nigerian Stock Exchange for Nigeria. For London, it's under the London Stock Exchange, LSE, and we know the famous or the popular New York, it's NASDAQ or NYSE that is called. So these different jurisdictions have their own institutions set up to trade the stocks publicly under their own platforms. So, and it's regulated by the Securities and Exchange Commission in Nigeria. The minimum share capital and cost of running a public limited company is considerably higher than that of a private limited liability company. Therefore, a publicly limited liability company is better suited for large organizations. Now we have company limited by guarantee, often designated as LTD or GTE. Company limited by guarantee in Nigeria is an alternative type of corporation used primarily for non-profit organizations that require legal personality. A company limited by guarantee does not usually have a share capital or shareholders, but instead has members who act as guarantors. The guarantors give an undertaking to contribute a nominal amount, typically very small, in the event of the winding up of the company. The other one is the unlimited liability company, often designated as the ULTD. An unlimited liability company is a type of company having the liability of its members unlimited by the memorandum to any amount. In the event of being wound up and its liabilities exceeds its assets, in other words, where it is insolvent, the liquidator will go to the members asking for contribution, that is, in proportion to the number of shares they hold, to make good the deficits. The joint, several, and non-limited liability of the members to meet any insufficiency in the assets of the company or to settle its outstanding liabilities if any exists applies only upon the formal liquidation of the company. Incorporated trustees. Incorporated trustees are non-business and non-profit making organizations formed to facilitate the acquisition of corporate personality by a community of persons bound together by a common interest, which may include but not limited to custom, religion, nationality, or it could be an association of persons established for religious, educational, literary, scientific, social development, sporting, and other charitable purposes. This is well captured and defined under section 590 of the CAMA. It can be registered under Part C of CAMA and, however, operates without registration. But when it operates without registration, it cannot take advantage of the corporate identity of the trustees. Now, bearing this in mind, one may ask, what's the benefits of entity formation? Let's look at the benefits of entity formation. So, the benefit of entity formation includes, in Nigeria for instance, you can protect your personal assets and determine your extent of liability. You can minimize your tax exposure and attract some government incentives. You can consult your tax lawyer for advice. There are many incentives you get when you set up a corporation. There are many things you can discount in form of that. That's typically obtainable in North America. So many things, many expenses that you can get into your corporate organization, and it reduces your personal tax. It enhances, besides the other tax incentives that you can get, especially when you are novel in an area, you are leading a new formation of, you're venturing into a new area of business that has not been there before. The government can give some incentives to encourage people to venture into that industry. It enhances your business credibility and creates brand awareness and legitimacy. It creates easy access to credit facility from banks and other financial institutions, including investors. It gives easy access to grants from government, development partners, angel investors, and INGOs. It makes you look serious and attract more customers and clients. Some clients wouldn't take you serious if you're not a registered entity. There is little or no limitation to expressing your creativity or ability to innovate. A lot of leadership and management decisions are within your control, and it gives you anonymity. Well, for the issue of leadership and management decisions within your control, those are peculiar for business names and sole proprietorship. And that also includes your ability to innovate and express your creativity, or ability to do what we usually call freestyle, do things the way they come to you. These are peculiar to one-man business, the sole proprietorship. But just bear in mind that individuals, proprietors can register business names without the services of a legal practitioner, chartered accountant, or even chartered secretary. Yes, the Corporate Affairs Commission have relaxed some of these rules. So as an individual, you can walk up to CAC and register your business name. But it's always wise to run these things by your lawyer to ensure that all your I's are dotted and all your T's are crossed. Should you have questions with respect to entity formation, do not hesitate to reach out to me, and do me an email and I'll be glad to take your questions. Till then, get ready as we prepare for contracts. Thank you for listening. Looking forward to seeing you at the next slide. Bye now.